One of the most confusing maxims of equity is that equity acts in personam. There are two types of legal action: in rem against the thing and in personam against the person. Identifying the difference can be very difficult even for the court. There's no neat distinction. Why does equity act in personam? Equity is the law of conscience. Equity binds the conscience of the defendant, and only the defendant, and says what they must do. As a matter of logic, it's necessary to identify the defendant, to identify whose conscience is going to be bound. This case from the United States involves the registration of several parcels of land. The plaintiff sought an order of prohibition to prevent the registrar from registering these parcels of land on the basis that the registration statute was unconstitutional. The distinction between in rem and in personam mattered because if the action was in personam, then the defendant should be served with the claim to preserve due process, and the statute did not require this to happen. So the court had to work out whether this was a claim in rem or a claim in personam. One of the greatest American judges, Oliver Wendell Holmes Jr, then the Chief Justice of Massachusetts, said, "If the technical object of the suit is to establish a claim against some particular person with a judgment which generally, in theory at least, binds his body, or to bar some individual claim or objection so that only certain persons are entitled to be heard in defence, the action is in personam, although it may concern the right to or possession of a tangible thing. If, on the other hand, the object is to bar indifferently all who might be minded to make an objection of any sort against the right sought to be established, and if anyone in the world has a right to be heard on the strength of alleging facts which, if true, show an inconsistent interest, the proceeding is in rem." From this case, we learn that a claim binding on an individual person, such as a claim in tort, which binds them individually, is a claim in personam. A claim binding the whole world, like an application for probate or an application to become a legal practitioner, is a claim in rem. Don't be fooled though, the distinction remains elusive and complicated.